All right, so moving forward, one of the things that we really wanted to do here today is to do a deep dive into the Dobbs case. So Dobbs is the case that has allowed the Supreme Court to find that they wanted to overturn Roe and Casey cases when it came to abortion rights. So as we're diving deep into the Dobbs case, the reason why we're doing this is because there is a lot that has not been disseminated to the public, mostly just because this is an over 200-page court document. There's so much here. So we really wanted to take the time to go over this and bring this to you. So we're going to kind of do a bit of a legal analysis of this. Both Michael and myself have legal backgrounds, so we're going to try to move through this pretty quickly, but also give you the information from the inside of this, the concurring opinions and the dissenting opinions, because there are quite a few nuggets that are making both me and Michael a little concerned for our future. One of the things that happened in Dobbs was the issue before the court. So that was that the state of Mississippi was asking the court to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy. So this is several weeks before the point at which a fetus is now considered viable outside of the womb. So in both Roe and Casey, this aspect about viability of a fetus was a big talking point. It was something that was examined by the court. And one of the reasons why this Supreme Court justices felt in this case that they were going to be able to overturn both Roe and Casey. The broad question that was being examined by the court when it came to Dobbs and overturning Roe v. Wade and Casey v. Planned Parenthood is whether the Constitution itself, confers a right to obtain an abortion. And so there were a few factors that were looked at when it came to whether this right is in the Constitution. And these were also explored in Roe and Casey. And that was looking at the 14th Amendment's liberty protections of a particular right, whether the right to obtain an abortion is in our nation's history and tradition, and whether the right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. And then the second aspect that the court was looking at is a very legal term called Starry Decisis. And so this is a role in protection interests of those who have taken an action in reliance on a past decision. So basically this is a case that has been decided and other people have relied on this court's case decision in moving forward. And by having that case decision, more laws and more movements can be made based off of that particular decision. Looking at the findings by the court, they found that the 14th Amendment does not protect the right to an abortion. And that was their big decision when it came to overruling these two cases. And they said that at the time of the adoption of the 14th Amendment, over 3/4 of the states had adopted statutes criminalizing abortion, and that from the earliest 20th century until the day Roe was handed down, every single state had such a law on its books. So we're going to get a little bit more into that in just a second. But I wanted to also bring up some of the precedents that they used in the second aspect of why they were wanting to overturn these cases. And that's looking at the Brown versus Board of Education, Plessy v. Ferguson, and West Coast Hotel Company v. Parrish. So these are kind of the three seminal cases that they used in overruling precedents. So basically, these were cases that overruled previous court decisions. And they used those three cases to say that that is why they can overrule Roe and Casey, get rid of them, and move forward with the Mississippi case in Dobbs. So Michael, do you want to just kind of give us a little bit of a rundown of like kind of your initial thoughts on this, and then kind of some of the other factors that came through when it came to overruling Roe and Casey?
Yeah, so, I mean, there's a lot to unpack. Like you said, it's a very lengthy opinion from a court.
Mm-hmm.
And I think my probably initial reaction and everything was, not surprised given how the court has turned, but also because from a constitutional standpoint and from a legal aspect, the court's not wrong. Like they had plenty to kind of say, hey, it was never right in the first place and we never should have done it.
Mm-hmm.
Obviously, the problem with that is it's been something that's been essentially on the books, even though it's not officially on the books, which is kind of another problem that I'll bring up about the common law system, is that now you give it back to states and supposedly everyone has more control in your state because you have a little bit more direct action on who represents you. But it's essentially the same people who've been there for a long time, and they already had, as we saw, laws ready to just trigger just like that and vastly restrict abortion rights. And I also think there's some issues with the 3 cases you mentioned that they used to kind of justify why they could overturn this on top of the constitutional aspect of it. And then, so I mean, I think it's important, like Roe essentially used privacy, which is it's not mentioned in the Constitution. So that was kind of a tricky sticking point, that when the court first ruled in Roe that privacy was covered as a fundamental right, it wasn't really, but they said that essentially the common law tradition and history from the late 1800s to the mid 1900s had established an individual's right to privacy. So you kind of already see there they established a history and tradition, and that was in specific areas of life, whether it be medical, psychological, or family. And in Roe, they ruled that women had an absolute right to abortion for the first trimester, and we kind of went through the trimester framework. And then once Casey came about, Casey really didn't change too much from Roe, but what it did was it changed it to the viability standard that we had. They expanded on Roe, and instead of using privacy, they used 14th Amendment's due process clause looking at liberty, because they define liberty, the right for an individual to be protected from state procedures. And at the core is essentially how someone kind of defines their life. And again, they held under common law through history and tradition that constitutional protections regarding liberty are well established in law and substantive law and procedure. So they acknowledged essentially that society would disagree over morality is going to forever be present. But the courts can't allow that disagreement to drive law, which is interesting that in Casey, they hint at morality should not be what drives the law. It should be what is in the best interest of the public and the individual. And then they also refer to the 8th Amendment about the burden, cruel and unusual punishment. They refer to how the burden that is incumbent upon a woman who considers or has had an abortion, or to see pregnancy through, is a significant strain on the body and mind. So they make a lot of points about how there are several constitutional amendments that can be applied to abortion. And then I did check with several pastors because I wanted to be sure. The Bible does not specifically ever mention abortion. The only time it's really mentioned is not actually by name. It just implies that when a fetus is lost through someone else's action, that the compensation is that of property. So that's an important aspect to note, that it's not actually mentioned in the Bible and it's viewed as property until it's born.
Interesting.
Yeah. And then once, we get into Dobbs, like I said before, they're not technically wrong for overturning it, because they viewed it as that the amendments in the Constitution only protect substantive rights, which are those that are enumerated in the Constitution. right? So that's 1 through 9. And then fundamental rights are just those that are implied rights, which is kind of what, in essence, the Ninth Amendment refers to when it's talking about, it's anything that's not enumerated should not be thought of as an exhaustive list of all rights. Other things that are not are retained by the people. And then, kind of, as you mentioned, there's this long history and tradition of, abortion laws and criminality, whether that was before fetal movement, post-fetal movement, wide-ranging aspects of it. But it was all at the state level, which is kind of the important part, is that people actually had more control. Although I would mention that when the 14th Amendment was adopted, it was in the mid-1800s, and it wasn't until the 1920s that women had the legal right to vote on issues. So I think that's kind of an important aspect that they don't really mention. And as you went over, kind of the problem with saying, using Plessy and Brown as examples as why they would overturn, and go away from stare decisis, which they said was essentially a recommendation. They were not bound by something that the Supreme Court has used for centuries, was that Plessy and Brown were giving rights to people and actually went against history and tradition in the American legal system, because up until that point, the American legal system was very skewed as to taking rights away from minorities. And it wasn't until those two cases in particular that they actually got rights. And they said, the court said, no, they've always should have had these rights. So it's kind of a weird comparison to make, that we're essentially taking a right away that was never really a right because we ruled wrongly. But we're going to refer to cases where we gave rights. So it's kind of like we're kind of picking and choosing what history and tradition of law that we're actually going to follow. So it's an interesting way of wording some of their arguments.
Yeah, it was really interesting. In the dissenting opinion, they kind of talked about it. There's a lot of hypocrisy going on with the majority opinion overruling this case because of those precedents that they were using, like you said. Because they were giving rights, not taking them away. And the other thing, too, is that both Roe and Casey had been understood for a good 30 years plus. And even some of these Supreme Court justices, as they were being put up as nominees to the court, they said that this was something that they were going to retain, that they were not going to do anything with it. But there was, of course, the understandable fear from many that just because they say this doesn't mean that that's actually what they're going to, that they're going to hold to that. And that has been the overwhelming concern, even since the Roe case was handed down, because we knew that there were a lot of loopholes and legal areas of gray that could lead to something like this happening, which was why so many people over the last several decades have talked about the need to codify this into law. And especially now with this case coming down, it puts a lot of other rights into question. So that comes from, contraception, same-sex marriage, interracial marriage, things like that. So it's one of those things as we move into some of the concurring opinion aspects from Justice Thomas that are very concerning because of just the language that he's using. It's very to me, it's a little bit forceful, but it also feels like it's kind of a roadmap for the ultra conservative case of moving away from looking at a broader aspect when it comes to our laws and just focusing only on what are the rights that are in the Constitution. Because that, as we know, like you were saying, in the 1860s, women didn't have the right to vote. That was in 1920. So a lot of the case law that they were looking at in the majority opinion, some of it took place in the 13th century, the 17th century. They were, looking at some things that happened in Europe. I believe believe it was like in France. They did a lot of language analysis of quickening, pre-quickening, when you would feel the baby move, things like that. And it's just in all of those aspects, as the dissenting opinion kind of talks about, women were not looked at as a full-fledging, human being that had the full rights and protections under the Constitution. So it's like, so my concern, as we're in 2022, is this going to be a recurring thing where it's, oh, we're just going to go back to the Constitution? What does the Constitution say? Because women had no choice in the Constitution and how it was written. And even our amendments that we do have do leave a lot of, I think, kind of leeway and gray areas for us. And I kind of wish we could just redo our Constitution because things have so drastically changed. What's your thought on that about changing the Constitution?
I think that'd almost be impossible now. Yeah. We can barely get, politicians to agree on anything other than things that serve their special interest rather than
their favorite
interest.
Corporations.
Yeah. So, changing the Constitution or redoing it all, I don't even know if it's possible or, what it would look like. I don't even know if you could get enough states on board with, changing it, to be able to ratify, to get an amendment. There's so many problems. But I think one issue, especially when it comes to law, and especially constitutional law, is that it's very open, as you said, to interpretation. And I would argue that it's not so much the Constitution that is wrong per se, but it's how legal scholars interpret it and apply it to the world. So they kind of interpret it and go, oh, well, I'm going to look at it from exactly how it says in the 1700s, as opposed to understanding that even the founders kind of talked about this, was that there were some founders that didn't even want the Bill of Rights in the Constitution, not because they didn't think people deserved them, but because they didn't think that you should have to enumerate rights that were just blatantly obvious. You said in different terms, but that's essentially what they said, was we shouldn't have to enumerate rights because everyone knows that you should have them. So why put these in here? Because they were fearful that it would lead to essentially kind of what we're facing now, that, well, because it's not there, you don't have that right. Where they're like, well, there's a lot of kind of nuances, which is why it makes constitutional law very difficult to tackle. We can also look at, there's a whole bunch of other cases that the Supreme Court has done throughout history, and just other things that have happened. They didn't even have, technically, the Supreme Court also doesn't technically have the constitutional authority to do judicial review. That's nowhere in the Constitution that they have that. They actually gave themselves that authority and power through one of their own cases, which is kind of ironic. But, then you have, up until the early 1900s, women were primarily the ones in the OBGYN practice. It was nurses and midwives, and then that shifted to being male-dominated professions at the time, as doctors. And then they kind of started taking that over. So then there was that shift, and that's when you start seeing all the abortion bans and the restrictions on abortion and all the slew of things. There's a lot of different cases. In the 1920s, there was sterilization acts, there was eugenics acts, a lot of them targeting women of all, ethnicities and races. It wasn't just specifically targeted. There was some that were very targeted, but there was many that, were targeting them that were essentially using a Supreme Court case that had to do with mandatory smallpox vaccines to justify tying tubes. So there's a lot, the Supreme Court's decisions have such a wide sweeping impact that I don't know if they even fully understand the impact that was created and all the ripples that will now, I mean, for probably decades, come from this decision. And then I know as we're going to get to the concurring opinions, at least one of them from Thomas is concerning, to say the least.
Yeah, so let's get into that, because so Justice Thomas, he's a particular figure, and I don't agree with many of his positions. One of the really concerning aspects in this case, so in his concurring opinion to the majority's decision to overturn Roe and Casey, he said this particular thing: substantive due process is an oxymoron that lacks any basis in the Constitution, because the Due Process Clause does not secure any substantive rights. It does not secure a right to abortion. And then he goes on, he says, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Because any substantive due process decision is demonstrably erroneous, we have a duty to correct the error established in those precedents. And so that right there, like, I have not seen anyone really talking about his concurring opinion in this, just because it is such an eye-opener to what he's thinking, what I think that a lot of conservatives are thinking. And I felt as I was reading this that he is giving them a roadmap of how to go about doing this. Can you talk a little bit about the effect that this is, like, if something like this was to happen, what would that effect look like?
I mean, that effect, I mean, all those cases have to do with, gay rights, marriage rights, healthcare for a lot of certain things. I mean, they could essentially apply to almost anything that the court has ever reviewed, that they feel that is, substantive in nature. And I feel like it's a weird thing to cover, because, the court has a history of covering that the Due Process Clause, and which is found in several areas of the Constitution, it's not just one specific spot, does cover those rights. And I think the fact that he's saying that it's because it's not enumerated in the Constitution is essentially what he's saying is because it's not enumerated in Amendment 1 through 8, even though 1 through 10 is the Bill of Rights, technically they look at 1 through 8 as the substantive rights. Because it's not listed in there, it doesn't exist, which, I mean, has so many implications. I mean, it's almost impossible to, it's almost impossible to know what it could mean, because you could argue that a lot of the things when it comes to privacy, that the Fourth Amendment has been used to cover for your privacy when it comes to data, online presence, even some stuff with your home. Well, technically, there's a lot of things in there that could be viewed as, well, it's not actually enumerated. It just says life, like property, things of that nature. So then you would have to get into legal battles of, all right, well, what constitutes property? And if they went back to an older, pure, I don't even know if it's really pure constitutional view of property. I mean, you could be looking at so many different issues just on the property aspect alone. All the things about free speech. Free speech is covered under the First Amendment, but there's been a lot of case law that kind of curtails certain things and allows other things, but that could go away. The Second Amendment's always a hot topic. I think it's never going to be, a cold topic in the country, but I mean, that could be another thing that people that are, wanting more restrictions on guns in the Second Amendment, that could get taken away, and you could just essentially get whatever gun you want to, or who knows what. So his opinion and kind of how he's laying it down is is concerning because he essentially just kind of says, hey, we're just going to toss out everything that we've done and we're just going to go back to just the Constitution and that's it. We're not going to look at anything else, which may have been fine when the country first started and had its first few cases and you didn't really have much to go off of, but not when you've had, a couple, 200 years of legal history and tradition. I don't know what legal history and tradition that would be following, and that's in their own majority opinion is what they say, or they base things off of. So
there's two other things I wanted to mention of the Thomas opinion. So it's him talking about jettisoning substantive due process because it's particularly dangerous. And he says that it exalts judges at the expense of the people for whom they derive their authority, that substantive due process distorts other areas of constitutional law, and that it's often wielded to disastrous ends. And then he goes on to say, in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. It's just so to me, because it's like you can be one of those justices that is, primarily only looking at the Constitution. But for someone like Justice Thomas, who has quite a history when it comes to his opinions and his decisions on cases, to now be bringing this, that he's wanting to basically go back to at any, like, the first opportunity that they get to get rid of substantive due process. It just feels like it's kind of getting rid of any progress that we've made when it's come to understanding rights and privileges and liberties and protections for people within that. Because, when you look at life, liberty, or property, when it comes to the Constitution itself, that was only looking at life, liberty, and property pertaining to a particular aspect of the population. So it's one of those things where I'm like, does he understand? I'm sure he does, but it's like the question I have in my head is like, do you understand what you're doing? Like you're taking away so much progress if this is something that you want to move forward with.
Yeah, it's difficult to understand where he's kind of coming from. Because I'm not sure what does he want to go back to, because it's essentially saying that these don't serve any legitimate purpose and we don't really care about the fairness or, equality of the law, which, I feel like the founders' whole idea was that the Constitution and law system was supposed to protect individual rights and serve the public interest. So I'm not really sure how getting rid of this due process aspect that the courts have used for a very long time would really serve any individual's best interest, maybe a select few's best interest, but I don't see how it could also either, serve a public interest, because if you just take one of those cases, and I'm pretty sure it's Oberfell that has to do with gay rights and marriage in particular. If you get rid of that, well, you're just now essentially taking away a right from a whole part of the population and essentially telling them that they're wrong, like you never had this right, which again is the exact opposite of what Plessy and Brown did. So It's very bizarre that he would be so heavy-handed with, this opinion and wanting to eliminate it from jurisprudence altogether, which I don't think would actually happen. That'd be a very difficult thing, I think, to really implement, because that would change too many things. But it's just bizarre because the court itself, even in most of their majority opinions talks about the due process clause and its how it protects certain rights, but then also takes into account history and tradition and everything. So, I mean, essentially, like I said before, if his opinion is the future, they're going to take everything that the legal system has done and kind of just toss it out the window and say, well, we're just going to start fresh, which, I mean, you could look at it as maybe a positive if, the legal system functioned the way it should, but it doesn't.
Word. That is very true. I mean, I definitely think that it's one of those kind of like long game opinions, because I think that the only way that you could really overturn Griswold, Lawrence, and Obergefell is by looking at the substantive due process. Because it was, it's even things that they did try to use in both Roe and Casey to say that, this is why this right to an abortion is so important. Yes, it might not be, delineated exactly in the Constitution, but it comes from this aspect, this broader aspect of, what are our own personal rights that we can have. So the next thing I wanted to move into while we still have some time is the Roberts concurring opinion. So I think both me and Michael, as we were looking at this, kind of agreed that he had a little bit more of like a steadied stance when it came to his concurring opinion, because he agreed, but kind of up to a point with the majority decision. He didn't believe that they needed to do a full overturning of Roe and Casey. He felt that that they could have recognized the right, but also reaffirmed the doctrine of stare decisis, so keeping those cases intact. Because we know that there are other cases like Griswold, Lawrence, and Obergefell that talk about Roe and Casey in their within those factors in deciding those cases, because it was both of those, Roe and Casey, were seminal cases for the court. One of the things that, Roberts talked about is, looking at the two distinct rules of constitutional law. So that a woman has the right to choose to terminate her pregnancy, but that such a right may be overridden by states' legitimate interests when the fetus is viable outside of the womb. I felt that was, like, as someone who is pro-choice, this part of his opinion I agreed with pretty much, because I'm like, I understand that there are going to need to be some aspects in law in states that look at, the timeline of the pregnancy, and that at a certain point, getting an abortion is considered too extreme. Those are things I don't disagree with. I just wish that there was more like medical professionals that were kind of part of the discussion that can, look at just science and biology and facts to kind of help understand what the actual timelines are. Because like we looked at, with the Ohio case, they only have a 6-week. Florida, Mississippi, and a lot of other states, they have 15 weeks. But in like the Facebook case, I can't remember which state that was in, but they had a 20-week. So it's like there lots of states seem to have an understanding of the viability of the fetus and the timeline of the pregnancy and when it's okay and when it's, not okay to get an abortion. Was there any particular areas of the Roberts opinion that you found kind of intriguing as you were looking at it?
Yeah, I mean, I think the big takeaway I got from his opinion was that he recognized that, I think the biggest one was that he would essentially get rid of the timing rule, but didn't see any need to kind of address the basic right itself, like the right to get an abortion. So, I mean, he's smart enough to know that there's never going to be a consensus of when life begins. If you look at religion, a lot of them will say conception. If you look at science, it's usually anywhere between, I think, 24 to 28 weeks, typically, somewhere in there. And then, philosophically, it's a whole different answer. It's essentially like, when can
Yeah.
you reason is when life begins. So I mean, you're never going to have, the triangle of thought agree on one thing, especially on this. And Roberts kind of gets at that by saying, yeah, we don't need a timing rule. We can probably get rid of that, but they still have the right. Like, there's no need to take away this right. And as you mentioned, from 73 with Roe to 92, it's almost 30 years of basing a lot of things. There's a lot of abortion cases that came between that time frame that used Roe as a standard. Then after Casey used Casey as a standard, and then many other rights were justified using the rulings in Casey and the rulings in Roe. So I think Roberts is kind of a little more restrained. And as he says, we need to resolve something a little bit more narrow and not be so broad and sweeping with this decision. He thinks it's fairly grounded in Starry Decisis. So he's very much, hey, this has been a thing for a long time. There's no need to overturn it. We can maybe make some adjustments to it. Obviously, that did not happen, and they, overturned it. But it's comforting to know for Roberts, who is actually more conservative, that he still recognizes that there's not a reason to really overturn this. Like, you could keep this right and maybe kind of, I guess, I don't say chisel away, but that's kind of what he hints at. Like, maybe chisel it down a little bit, but still afford that right to the people. I think probably what the better solution, in my opinion, would have been, a woman has the right to choose, and the medical professional decides if it's a good idea or not. I mean, I know the right kind of likes to say, hey, people will run around and at birth getting abortions. I didn't do the research on it, but I have a feeling it's probably not that many, if any, are doing that. And if that is the case, it's usually because something has gone wrong, very wrong. And, it's more of the safety and well-being of the mother or child, depending what the circumstances are, that something's going to happen. But usually, most cases are still within the viability framework that was established in Casey. So I don't really think there was really a need to get rid of it. I mean, this is kind of one of those ones where you're not really winning, and you're also not really losing, depending what side you're on. So
yes,
it's
I agree.
It's tricky, because some people would say, it's great. Like, the conservatives were like, yeah, it's great, we got this overturned. But then you had the incident in Kansas where they tried to amend the Constitution to restrict abortion, and the people were like, nah, it ain't gonna happen. So
That's right. Yeah.
so I mean, it's a rebuttal of what and I would like to say, it's not all conservatives. I think it's a very small wing of the conservative party that unfortunately gets all the media attention, just like a very small wing of the Democratic Party gets a lot of media attention, and all the other areas that exist are kind of left out and forgotten about. And the unfortunate part is that that's where most people fall. Like, you could be conservative on gun rights, but be, liberal on healthcare, or, in a whole bunch of different areas. But those two extremes kind of get all the attention.
Yeah.
And they drive the policy, which is the unfortunate part, is that they're driving public policy when majority of Americans, I think, like a Pew Research poll was showing, that almost 85% of Americans think that in some fashion abortion should be allowed and should be a right, which that's a lot. Like, there's almost no issue that gets that much support from the public. So,
and that was one of the odd things in the majority opinion, because they were trying to act like, there's so much showing us that it's a varied lot when it comes to whether people believe women should have this right or not, whether, we should just get rid of abortion entirely or things like that. And I'm like, are they looking at data? Are they looking at polls? Are they looking at, what the people are saying? But there's also that whole thing of like, that's really not what the Supreme Court is meant to do. They are
No.
looking at case law and looking at it through what they have available to them. And that's where it's I was so back and forth with the majority decision because, like you said at the very beginning, it's like you can see where the holes are in Roe and Casey and why this ultimately got overturned. It's like you can understand little tiny aspects of the majority decision, but trying to act like this isn't something that the broader public agrees on of just the pro-choice aspect. It just seemed like that's not something that they're looking at, even though they were using that kind of when they wanted to in their opinion. And that was what the dissenting opinion really talked about from Breyer, Sotomayor, and Kagan. They were really looking at the hypocrisy of the majority opinion and also just kind of their inability of looking at the what they called it, the geographically expansive effects of its holding. And they kind of called a few things. They talk about like interstate restrictions will soon be in the offing. And I found that really interesting because I'm like, yeah, they basically called what happened because like there's already been some states that are looking at restricting the ability of women to go to other states to obtain these services. But also just that the majority doesn't really seem to know kind of what they want to use and hold to that because they were using so many different, like I said at the beginning, 13th century, 17th century, and some 19th century things when it comes to health. They kind of really were not looking at the fact that women did not have rights at the time that the Constitution and the Bill of Rights were made, and that if you were to look at what's deeply rooted in our history today, it's that people do believe in a woman's right to choose, that this should be linked to healthcare. And I mean, a host of other things, like that we should have more of a universal healthcare system that brings these kinds of things into the fold. Was there any particular thing in the dissenting opinion that you found intriguing?
Yeah, I'd say all of it.
Yeah.
I mean, because I think they just did a really good job of, they touch on essentially all the things that the majority just kind of let fall by the wayside.
Mm-hmm.
They talk about the geographic implications, which we kind of talked about. Now you have to pay to go out of state to do it. Well, who does that really hurt? That hurts the economically disadvantaged.
Mm-hmm.
You're putting more toll on people to go do this, which would be fine if this was like, a law concerning, murder, robbery, things like that. That makes sense to have a punitive aspect to it, but not something that in reality, this should not be that level of criminality. But that's kind of what they're trying to make it. They also talk about, the rights have a history back to the mid 19th century, what we also talked about. Before the overtaking of, OBGYN care by the doctor profession, it was handled by nurses and midwives, which were predominantly women-led fields, which had a very different approach to abortion and care and all of that. And then again, they also talk about how they relied on abortion and how, it helps into planning lives, how it can kind of work on, even if you want to say you shouldn't use abortion to plan your life, well, you could still argue for all the exceptions, for rape, incest, all these other things that some states aren't even accounting for and that the majority decision didn't account for. It'd be different if they worked in that there are, exceptions to apply into this rule that, but they didn't. They just kind of went with this blanket. We're just nixing all of this. And it's kind of telling when you have a majority decision that references really far back case law
Yeah.
and then contradicts itself when it talks about the history and tradition of American law
Mm-hmm.
for overturning things, but then overturns something that, yes, technically was never an inherent right through the Constitution, but was a right nonetheless through case law and the history and tradition of the legal system. I'd also say that, politicians have had since 1973 to codify Roe and Casey, and then Casey
Mm-hmm.
92, which is still 30 years or so. I mean, there's been so much time to actually get this to either a constitutional amendment or to put this into federal law, which
Mm-hmm.
usually states will states follow. So I mean, there's so many opportunities that were missed before this case even came up that I think things should also be addressed. That
Mm-hmm.
The politicians who are supposed to represent the people kind of dropped the ball on, that I think that even the dissenting opinion kind of touches on in a way.
Mm-hmm.
Because I mean, they go on and talk about ratifying the Constitution. That when the 14th Amendment happened, women didn't have the right to vote. Women weren't involved in the process. They talk about how it says "we the people." There's no mention that women aren't included in people in the Constitution. People
Mm-hmm.
was all inclusive of all individuals that were citizens of the United States. I mean, it also says citizens throughout the Constitution. That it doesn't even make mention of any type of gender. So
Yeah.
it's kind of sad that unfortunately only 3 people took that dissenting opinion, even though I'd argue I think Robertson in a way kind of wanted to dissent. He just didn't.
Yeah, he was going with the group, the peer pressure.
Yeah.
There were some really startling statistics and facts that the dissenting opinion put out, so I definitely want to cover those before we go. So the first one is that an American woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. Experts estimate that a ban on abortion increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality, while Black women face a 33% increase. Many women still do not have adequate healthcare coverage before and after pregnancy, and even when insurance coverage is available, healthcare services may be far away. One of the things discussed in the majority opinion that the dissent talks about, which is the majority tried to say that women don't really experience discrimination because they're pregnant. These are things that we have, laws or understandings, but the dissenting opinion says that women continue to face pregnancy discrimination that interferes with their ability to earn a living, and that paid family leave remains inaccessible to many who need it most. There's also only about 20% of private sector workers who have access to paid family leave, including a mere 8% of workers in the bottom quartile of wage earners. There was also another aspect of the majority decision that the dissent talks about, which is safe haven laws and the demand for abortion. This was something that was kind of briefly discussed as the leak of the Roe overturning happened, and that was talking about the I can't remember the exact term. I'll put it up on the screen. But it was talking about the availability of babies for adoption, and that it was I think it was 2003, that we didn't have enough of a supply of babies for adoption. But it just seems that putting women at a risk of having to not have the financial ability, the maturity level, do they even want to partake in the task of having a pregnancy and bringing new life into this world, doesn't mean that we need to, evaluate the demand for adoption, which was just it was such a weird thing.
It's an odd supply demand market to be talking about in a legal opinion, but.
And especially when we have an entire foster care system filled with children, of course they're not babies. So it's do people just want little babies and that's all they want to adopt? Because there are tons of children that are in the system that do need good homes. Foster care is not what we really think it is. It's quite a nefarious institution, unfortunately. And there are so many children that could be in good homes if people weren't wanting just little tiny babies to adopt.
Yeah.
Which, yeah. Another key thing that they bring up in the dissenting opinion is looking specifically at Mississippi, because in the Dobbs case, this was looking at the Mississippi law of wanting to ban abortions after the 15-week mark. And they made a point to say that 62% of pregnancies in Mississippi are unplanned, yet Mississippi does not require insurance to cover contraceptives and prohibits educators from demonstrating proper contraceptive use, and that the state neither bans pregnancy discrimination nor requires provision of paid parental leave. They also have really strict eligibility requirements for Medicaid and nutrition assistance, which leaves many women and families without basic medical care or enough food. And this is unfortunately a really common thing, as the dissenting opinion talks about, that a lot of these states with very draconian laws on the books about abortion are also not providing any type of assistance and care to these women that are having to go through these pregnancies in these particular states. Lastly, just a couple other quick points that I thought were important to make. They said that 86% of pregnancy-related deaths in the state of Mississippi are due to postpartum complications, and that Mississippi rejected federal funding to provide a year's worth of Medicaid coverage to women after giving birth, and that Mississippi is the highest infant mortality rate has the highest infant mortality rate in the country, and some of the highest rates for preterm birth, low birth weight, cesarean section, and maternal death, and that it is approximately 75 times more dangerous for a woman in the state to carry a pregnancy to term than to have an abortion. And they also have no exception for rape or incest, or even if it's an underage woman. So, quite an astounding dissenting opinion. They have a lot of facts. Everything that we've been talking about today is going to be linked in the description box below. We know this was a long one, but thank you everyone for sticking with us and watching this. Michael, do you want to close out with kind of just go over your thoughts of this case moving forward, and then where can people find your work?
So I think probably the biggest thing to take away from this case is just that the implications and effects are going to be unknown probably for a really long time, because we don't know how it's going to affect things, what it's going to be looking at. It's going to be difficult to know exactly how far-reaching it goes and what the court might do in the future. But I think it's positive to think that there are some dissenting opinions, and there have been some wins, like in Kansas, and stuff. Yeah, so I think that the case has really far-reaching consequences. We're not going to know what those may be fully until more cases start coming up, which is unfortunate that more are going to have to come through the court system and have that long legal battle. But there's some positive notes. Kansas, they rejected the idea of amending the Constitution to ban abortions. And the dissenting opinion was pretty strong in its rejection. And even Robert's concurring opinion was also kind of a dissenting opinion in a way, because he's like, yeah, maybe we can change some stuff, but I really think we shouldn't get rid of this right. So when you look at it, if you view it that way, it was really a 5-4 split, almost down ideological lines. But only time will tell, unfortunately. And hopefully, the challenges that come up through the courts, hopefully Thomas doesn't get his way, because that could be really damaging to a lot of just rights that, we've just kind of accepted as being a right. It'd be unfortunate if people are going to lose those rights because they decided we're going to toss out stuff that we've been doing in the legal system for a very long time. And then if people want to check anything out, my Twitter is @thejustadvocate. I think you're going to link it below, maybe. And also my Substack is essentially the same thing, thejustadvocate.substack.com. And today I did release a new article. Has to do with a lot to do with the Dobbs opinion. It also kind of does a deep dive into the history or lack thereof of women's rights in the U.S. and kind of a lot of the legal implications that have been going against women throughout the history of the U.S.
And that is a great piece. I recommend that everyone check that out. Michael, I just want to again say thank you so much for joining with me today, discussing this very, very hot topic.
No, well, thank you for having me.
Yeah, very happy to have you. So stay safe, take care, and remember to be kind to each other.